and welcome to once again another session here at the Government Information Center. And I am your host, Shianwa Desire Kahia, for this afternoon. And today's topic, please do come closer, do tune in, because it's one that could be beneficial, maybe to you or maybe to your loved one or maybe to a friend. We are looking at understanding the proposed divorce law of Namibia. But before we get to that, today is Thursday, so we're going to be having two separate updates. Firstly, I'd like to call on Dr. Esther Mwinyangwe to give us the COVID-19 update for the 30th of March. Good afternoon, Doctor. How are you?
Ms. Kaiha Shinwa, I'm very well, thank you very much. I was listening how you pronounce the name today, but you did very well.
Thank you.
It did not sound,
I'm working on it.
Did not sound American, you know.
Thank you.
Thank you very much for giving me the floor to do the update for the 30th of March. And a very warm greetings also to our viewers and listeners. We announced 8 new positive cases from 808 results in the last 24 hours reporting cycle. That represents 1% positivity ratio. Out of the 8, 6 are females and 2 are males. The youngest one is 13 years and the oldest new case is 79 years old. The new COVID-19 positive cases are geographically distributed as follows. Comas 4, and all 4 are from Windhoek. Ohangwena 3, 2 are from Engela, and 1 is from Enana. Erongo 1, and that one is from Walvis Bay. We are not reporting any reinfections today. Among the confirmed cases, 3 are learners and 1 is a healthcare worker. 1 case is fully vaccinated, while 7 cases are not vaccinated. We are reporting 16 recoveries from 3 regions. Erongo has recorded 11 recoveries, Sambesi 4, and Hartap 1. Currently, the number of active cases now is 161. 9 cases are currently hospitalized in 4 regions. And very good news is that we don't have any case in ICU. But it is worth mentioning that all hospitalized cases are not vaccinated. The distribution of hospitalization of confirmed cases per region is as follows. Ohangwena 4, Sambesi 3, Comas 1, and Hartap also 1. We also have not recorded any death during the period under review. By 29 March 2022, a total of 442,685 people aged 18 years and older have received 1 dose of the COVID-19 vaccine, representing 30.1% of the target population, which is 1,471,973. A total of 130,776 have received the Johnson & Johnson vaccine, while 252,438 adults have received 2 doses of other vaccine types. That means that 383,214 adults have completed their vaccination, translating to 26% of the target population. A total of 128 individuals have received component 1 of Sputnik vaccine and 76 have received component 2 of the same vaccine. Therefore, a total of 204 doses of Sputnik were administered. 12,393 children between the age of 12 and 17 have received 1 dose of the Pfizer vaccine, and that represents 4% of the target population of children. Now, the target population for children is 307,298. Now, of these, 4,677 are fully vaccinated. Hence, the cumulative number of people vaccinated with the first dose of the COVID-19 vaccine for both adults and children is 455,078, of which 387,891 are fully vaccinated. That translates to 22% of the total target population. 39,523 people have received a COVID-19 vaccine booster dose. The summary of the national update as of 30th of March is as follows. Cumulative COVID-19 cases, 159,745, of which 155,550 have recovered. That gives us a recovery rate of 97.4%. Active cases are 161. Cumulative COVID-19 vaccine first dose, 455,078. Cumulative COVID-19 vaccine second dose, 257,115. Cumulative COVID-19 vaccine completed, that is those now who have the first and second dose, is 387,891. COVID-19 deaths, 3,689, while 330 people have died of COVID-19 related deaths. That is giving us a total number of deaths standing at 4,019. Total samples tested, 983,850. Active contacts are 66. Cumulative number of people who have been in quarantine facilities, 89,901. And 89,783 people have been discharged from quarantine facilities, and that leaves us with 118 people who are currently in quarantine facilities. That's the end of the update for the 30th of March. And I thank you very much.
Thank you very much, Doctor, for that update. And as Doctor keeps telling us, COVID-19 is still around. So can we please continue behaving as a nation so that we ensure that we curb this the surge or avoid the surge that we had last year around this time? It was definitely a trying time for the country. As I said, we are having 2 updates this afternoon, or pardon me, 1 update and a briefing. And with us, we would like to call on the Deputy Minister in the Ministry of Information and Communication Technology. That will be Honorable Emma Theophilus. Good afternoon, DM. How are you?
Very well, thank you.
Thank you.
Good afternoon to you.
Thank you
to our
very much.
panelists.
And it's great to see you. You haven't been on our platform for a while. So this afternoon, we're glad that we were able to grab you to do the cabinet briefing for today.
Thank you so much. It's so good to be back.
Thank you.
A very good afternoon to all the viewers and listeners at home. I'd like to issue cabinet decisions that were decided at the fourth decision-making cabinet meeting on the 29th of March 2022. Number 1, Cabinet approved the rearrangement of the shared river basin commissions set up and the creation of one team of river basin commission, where the Namibia's delegation will be made up of executive directors of the Ministries of Agriculture, Water and Land Reform, Mines and Energy, and Environment and Tourism, with the heads of the relevant departments, that is Water, Environment and Energy, serving as alternates members to be responsible for all the international shared rivers and watercourse basins. Cabinet further endorsed the appointment of technical personnel from the Ministries of Agriculture, Water and Land Reform, Mines and Energy, Environment and Tourism, International Relations and Cooperation, Justice, NamWater and NamPower to provide technical expertise to the river basin. And lastly, Cabinet authorized the co-opting of private individuals and or personnel from institutions of higher learning or any other institutions with expertise in river basin commissions and international water discourses to the River Basin Commission technical team on a needs basis. Cabinet decision number 2, Cabinet approved in principle the revised report on the International Covenant on Economic, Social and Cultural Rights. Cabinet directed the Ministry of Justice to commence with final validation of the report with relevant officers and ministries and agencies before submission to the United Nations Committee on Economic, Social and Cultural Rights. Cabinet decision number 3, Cabinet took note of the report on the 8th session of the Africa Regional Forum on Sustainable Development Goals that focus on 5 SDGs, namely Goal 4 on quality education, Goal 5 on gender equality, Goal 14 on life underwater, Goal 15 on life on land, and Goal 17 on partnerships. Cabinet took note of Namibia's nomination to serve on the Africa Regional Forum on Sustainable Development Bureau, and Cabinet directed all officers, ministries, and agencies to implement the resolutions adopted at the forum as outlined in Declaration 19 of the Kigali Declaration. Finally and lastly, the 4th Cabinet decision approved for the Ministry of Environment, Forestry and Tourism to host the Africa Youth in Tourism Innovation Summit from the 27th to the 29th of July 2022 in Swakopmund. That brings the end of the cabinet decisions at the 4th decision-making cabinet held on the 29th of March 2002.
Thank you very much, DM. And there are definitely some very good resolutions that have been, coming out of that particular one, especially one that's pertaining to the youth in tourism, I believe you said. That is one that we would definitely be looking into for a possible topic for the center. Thank you very much. Have a good afternoon. Back to our session this afternoon. As we were saying, we're looking at understanding the proposed divorce law of Namibia, and we have 2 panelists who are well vested in the sector of justice, and they will be helping us understand what it is that is currently in place and what it is the proposed law is bringing forth. We have Ms. Doris Hans Kaumbi, and she is a legal practitioner with the Waitele and Hans is it incorporated?
Incorporated.
Thank you.
Yes.
I'm not very familiar with the jargon, but I learn every day. Thank you for being with us this afternoon.
Thank you for having me.
Then we also have Ms. Felicity Kowoses, and she is the head of the Legislative Drafting Directorate of the Ministry of Justice. Good afternoon. I hope I did not kill the surname.
No, you didn't. Thank you.
Thank you for being with us this afternoon. Well, we fall right into it. Ms. Felicity, lawmaking is a process which takes time. What is the process that the proposed laws and or bills have to go through before they become adopted? I don't know whether that's the right term as well. You can correct us in that one as part of the governing laws of the country?
Okay, thank you for that question. Okay, so lawmaking process basically starts with people like you and me. You can initiate or influence lawmaking, say now on a certain subject. So, or it can come from something that has been raised in the National Assembly, or it can be as a result of an international agreement which Namibia has to implement. So these specific proposals are sent to the relevant minister. Say now, if it's something related to energy, it will go to the Ministry of Mines and Energy. Justice related, it will be sent to the Ministry of Justice.
Yeah.
So the responsible minister is basically the one that initiates the specific policy regarding the proposed law.
Okay.
So the responsible minister prepares a memorandum which the minister sends to the Attorney General's office. So the Attorney General basically just looks at the constitutionality aspects and if there are alternative ways in which the law can be dealt with or the proposal can be dealt with. After this, the responsible ministry basically prepares the memorandum for the Cabinet Committee on Legislation. This Cabinet Committee is chaired by the Minister of Justice, and they usually sit at the Ministry of Justice building. It is made up of a number of ministers, and I'm also part of the committee to advise in a legislative capacity. The Attorney General is also part of this committee. Yes, so this committee will basically look at the legislative proposal clause by clause, and if there are issues, it might be referred back to the ministry. Otherwise, they will approve it. And after the approval, the responsible minister has to send it to cabinet, who has to approve it in principle.
Okay.
So once the cabinet approval is obtained, the responsible minister has to ensure that the cabinet approval, the cabinet committee on legislation approval, as well as the bill and the relevant documents are sent to the department which I lead, the Directorate Legislative Drafting. There we will be drafting the legislation, looking at the legality, constitutionality, basically translating the proposed policy into legislation. And this is also where we have various consultations, or the specific drafts will go back and forth between the ministry and the drafters. Once we have done it, we'll ask the ministry if they are satisfied with the draft, and then we will certify the bill.
Yeah.
After the certification, we will send it to the Attorney General for his certification. Now, during this process, it may also come that the Attorney General identifies additional issues or constitutionality aspects, and the bill will go back and forth between the drafters, the Attorney General, and the client. Yes, once the Attorney General certifies the bill, it goes to the National Assembly.
Okay.
In the National Assembly, the bill goes through 3 readings. The first reading, the title is read out. The second reading, after the second reading, there are also various committees, standing committees in Parliament. So it's referred to the relevant standing committees, who may also decide that the bill, public needs to be consulted if they feel that there were no proper consultations.
Yeah.
Now, and then, the 3 readings, the National Assembly passes it, and it will be sent to the National Council, basically the House of Review. National Council also has its own 3 readings, and they may also propose amendments. So now, during the process that the bill is in Parliament, Parliament can make its own, propose its own amendments, and the specific drafters will be asked to deal with those amendments. After that, once the bill has been passed, depending on the majorities it has obtained, it will be sent to the President for his assent. The President assents the bill, and the bill is sent to the Government Gazette Office for publication. On publication, the law does not necessarily come into operation. It really depends on what the short title and commencement provision says. If it says that the bill is called the Public Service Act and will come into operation on a date determined by the minister, that law has to wait for that notice to be published before it's operational. But if it just says This act is called the Public Service Act. It comes into operation immediately. But this is also because maybe sometimes certain infrastructure have to be put in place or certain regulations have to be made, that the commencement of the laws are deferred.
Yeah.
So in a nutshell, that's how laws, how a bill becomes an act of parliament.
Wow.
Yes.
No, to somebody else, it might seem as if that was a lengthy explanation. But trust me, every day they say you learn something new. And in that explanation, I've actually learned a couple of steps that I never actually thought existed within the process. And I'm supposed to be well informed. So thank you for that one. But Ms. Felicity, we stay with you because we want to look at something else before we look or dive into the divorce part of our discussion. What is a civil marriage? And this I ask because it's on that basis that we're looking at this whole reform and so on. What other types of marriages are there, and what's the difference?
Okay, so a civil marriage is one that is ended in terms of the Marriage Act.
Okay.
You know, there are certain marriages that have also been ended into in terms of the SWAPO Family Act. And the recognition of certain marriages act. So those marriages are what is called civil marriages.
Okay.
These are different from customary marriages. And the divorce law just deals with the civil marriages, not customary law marriages. The ministry is in the process of coming up with reforms of to deal with customary marriages.
Okay. What is a customary marriage?
Customary marriage is a marriage entered into under the traditions and the customs of a specific traditional community.
Okay.
On Donga, for example.
Yes. Okay. So it's more on a cultural aspect, and
yes.
the other one is more on a,
Yes.
should I call
You
it
go into the
legal?
church, you get a marriage certificate, or a marriage officer officiates it,
Okay.
you know, and issues a marriage certificate.
Okay. Ms. Doris, we haven't forgotten about you. Now we're going to be hammering on you. What is a divorce?
So firstly, when you enter into a marriage, you must I always say this because I think people tend to forget that a marriage is a contract that you enter into.
Yeah.
So when you enter into a contract, in order to get out of it, there's a legal process which is called a divorce.
Yeah.
This basically assists with dissolving the marital bond because remember when you get married, you're bound to this person.
Yeah.
So the court assists by dissolving the bond. So the first thing that you would normally find on a divorce order is that the marriage is dissolved between the parties.
Yeah.
So the contract comes to an end. So that's what a divorce is.
Yeah.
Now,
okay.
that's in short.
Before we continue with the rest. Now, I also want to, before we actually go into the deeper part of the divorce process, many a times we hear of people being separated. What is the difference between being separated and being divorced? What are some of the reasons why people would choose to rather be separated than getting divorced? And what are some of the disadvantages of staying separated for too long?
Okay, so Namibia doesn't have a law that regulates separation. You would find, for example, in other jurisdictions, and let me make an example of Germany, for example.
Yeah.
Like they have it's like a requirement that before you file for divorce, you have to be separated for a year. Before you actually make the decision of getting divorced. But
Yeah.
in Namibia, we don't make provision for separation.
Yeah.
It's either you get divorced or you're married. What people tend to do is that sometimes because of costs, the costs that are involved in divorces, people decide that they're not going to go the route of filing for divorce.
Yeah.
What they would rather opt for is to stay separated. What people would normally say, and if I may use the term, van bed en tafel geskei. So divorce from just they're not staying together anymore.
Yeah.
So what the consequences of that is that you're no longer in the common marital home.
Yes.
Now that is one of the grounds for divorce. If you leave the marital home, you're actually at fault because there must be a reason why you're leaving.
Yeah.
So I know that my colleague is going to deal in detail with the reasons,
Yeah.
but that would be one of the reasons that would cause people to then eventually get divorced. So when people do separate, it basically means that we are not in a marital relationship in the marital home together, but we're still, for all intents and purposes, you're still very married.
Wow.
Now, what is the drawback? The drawback is that you find that people nowadays would come to you after 20 years of being separated. Now, in those 20 years that you've been separated, you've acquired assets. People have given birth to children.
Yeah.
But you're still legally married to somebody else, with the effect that when, God forbid, one of you dies, and then a estate has to be registered.
Wow.
I might have been separated from you for 20 years, but I'm still very much entitled to my 50%. So I can come and I can claim half of your house where you
Wow.
stayed, where you stayed with your girlfriend. I can come and claim 50% of the house where you stayed with your girlfriend, and she would have to go. I would have to sell. She would have to sell the house
Yeah.
because legally I would be the first person to be appointed as executor, meaning that I can come and say, "But you have to leave the house. This was your boyfriend, but it
Yeah.
was my husband." So that is the situation that a lot of people
Yes.
are currently under, and it's so sad because also
It's
with
painful.
pension monies, for example.
Yes.
I would be entitled to claim half of whatever the pension fund says I'm entitled to
Yeah.
by virtue of carrying the title of wife. So if you do not get divorced and you've been separated for how many years,
Yeah.
the effect is, legally speaking, I'm entitled to certain benefits.
Yeah.
And there's no way that anybody can take those benefits away from me unless I am divorced.
Wow.
I
That is actually painful. I'm not seeing it in any other way, but it is painful. Look, I understand if somebody decides, okay, let's separate for about a year or so, because you never know. People do change their minds after a while, or circumstances do change. But 20 years.
Yes.
Ah,
I
my
wanted to
people.
add on that.
Yes,
if I'm
please
allowed.
do.
What also happens is if you are separated, remember, because you are still legally married, say now the one party is listed on the ITC, you won't be able to buy property, for example.
Wow.
Or say now you are practically still responsible for each other's debts. So you can
Yeah.
even be sued for the debts the other person is accumulating in the meantime because you are, say now you are in community of property.
Wow.
So those are some of the drawbacks, yes.
Okay, so prolonged separation is clearly not advisable from what I'm picking up. I am still in shock because of some of these things. Because, you choosing not to get divorced immediately sometimes, as you said, it's a cost-bound thing also. But we will get to the costs a bit later on. Ms. Felicity, under the current laws, what are some of the elements of divorce, of the divorce law, looking at things such as the grounds that qualify for divorce, implications on the couple, how the process can be problematic to these couples?
Okay, so under the current law, there are 4 grounds of divorce. The first one is adultery. The second one is malicious desertion. Malicious desertion is when one of the spouses leaves the common home, but also when the other spouse makes it so unbearable for the spouse and the spouse ends up leaving the common home. The third one is incurable insanity. You can say mental illness.
Okay.
And a person has been institutionalized, so is under the Mental Health Act for 7 years. And then you have the habitual criminal. If someone has been declared to be a habitual criminal under the Criminal Procedures Act and has been in prison for almost 5 years. So under the current law, you have to prove fault except for the mental illness. You have
Yeah.
to prove fault under the on the part of the other party before a court will grant you divorce. Yes, so those are the 4 grounds. In terms of division of property, it really depends on the marital regime. If you are married in community of property or if you are married out of the
Outside,
community
yeah.
of property, whether it's with an accrual or not. So in community, like Doris said, is a 50% share. Out of community, it really depends on the agreement that the 2 parties have made. So basically, in a nutshell, that is, oh yeah, and in terms of the current divorce law, the court first has to grant what is called a restitution of conjugal rights order before they grant a final divorce order. And you have to wait for like 10 weeks before the final order is made. So there's no automatic divorce process. So, and that's also one of the factors that prolongs the divorce. The court is bound to give that order. Apart from that, what else? In a nutshell, that's what I could think of. Doris, do you have
Maybe
something
just
else?
to add on to, our system is fault-based, meaning that you cannot come to court and say, we don't love each other anymore. It doesn't exist. So people are basically forced to find a reason amongst those 4.
Yeah.
And they sound very simple. You must understand that when we talk about desertion, which is when somebody deserts you,
Yeah.
whether they do actual desertion, whether they take their belongings and they leave the house, or whether they make it intolerable, as she stated,
Yeah.
in the house. For example, they beat you up,
Yeah.
they emotionally abuse you. and the likes. So it's very difficult sometimes to classify the reason for divorce, because in practice, you come to a lawyer and you tell me your story, and I now, as the lawyer, have to decide, where does it fit in?
Yeah.
Is it malicious desertion? Is it constructive desertion? And we all know adultery. All of us can say that, no, the parties are in a relationship, but try and find somebody that will come and testify that these people actually have a relationship.
Yeah.
And we find it very difficult for people to come and say that these two are in a relationship. So adultery is also very, very difficult to prove. Now, what we're saying is, in South Africa, for example, we have the irreconcilable differences,
Yeah.
which is where you don't have to prove fault. It's just that we don't love each other anymore. We just
Yeah.
can't find each
They've
other
fallen
anymore.
out of love.
And yes, and based on that, so to a certain extent, it's actually correct if you say that we have made a choice to get married, right?
Yeah.
And we should make the choice to not be together anymore.
Yeah.
So it's very difficult to be forced to fall within a certain category when we no longer want to be together. So if one has to say, there's just no way that we can be together anymore, then one should be allowed to say that.
I like the way that you're saying it at the end there, as in, we chose to be in this. Now we're choosing to leave it. Can you please just allow us the platform to do so? I think when you look at it, it's one of those things where when people kind of prolong or uitstel
Yeah.
to get married, you are now listening to you guys. You are not fitting those puzzles pieces in to say, you know, it's probably because of this, trying to avoid some of these things that, you know, could come up. So the choice to get married is not as simple as it sounds, because you have to consider a lot of elements that could come down along down the road. Well, as we say, it's a national conversation. We keep saying this every single time. This is the platform where we engage you, and we want you to engage us. So you are welcome to make your comments, ask your questions where you need guidance about something. Our call line, the area code is 061. The number is 400-397. 400-397. You can also hit us on our social media platforms through which we are live streaming the show at the moment. We are at MICT Namibia, that's on YouTube. MICT Namibia, that's our handle there on YouTube. And Facebook, it is Ministry of Information and Communication Technology, Republic of Namibia. Ministry of Information and Communication Technology, Republic of Namibia. We continue with our program here, and I'd like to stay with Doris. When one decides to get divorced, what are the various steps that one has to take, and what is the possible time period that could be attached to this process? Just before you start answering that question, let me see. I believe we have a caller on the line. Okay, we're holding on to that one. Ms. Doris, you can continue with that answer.
Okay. So when you do decide to make that very difficult decision to end a marriage, you obviously are going to start off by making an appointment with a lawyer to consult, because you want to do that because you want to know what your rights are. It is not advisable for clients to do it on their own, because you might just not be aware of all your rights. So go to a person, just like you would go to a dentist for your tooth.
Yes,
to remove
definitely.
a tooth. I would advise people to obviously go to a lawyer to be informed about your rights. Now, the first thing is obviously when you come to a lawyer, you would come with your marriage certificate, because the first thing the lawyer is going to ask you is, how are you married? Are you married in community property, or are you married out of community property? If you're married in community property, we'll definitely advise you with regards to the fact that it is a joint estate, meaning that the day that you got married, whatever you had and whatever that person had was merged. It became one. So if I had $50, you had $50, we have 100 together now. So now, because we decided that we want to get divorced, it becomes 50-50 again. So there's a process to that, right? And like I said, we have to go to court to do that, so we have to file papers. Now, because it's fault-based, I have to find a reason why I'm doing this. And I have to say that the person I want to divorce is at fault. So it's either that person beat me up, or the person is psychologically and emotionally abusing me, or the person is having an affair.
Yeah.
So based on that, I would want a divorce. And on that paper, what we call is a combined summons, where you call this person to court to come and respond to the particulars that you've set out.
Yeah.
And the particulars would normally just set out the details of the parties that are married, the date on which they were married, as well as whether there were children born or not.
Yeah.
Now, why is it important to put whether there were children born or not? Because at the end of the day, when we decide to get divorced, we don't only deal with the proprietary consequences, we also deal with what happens to the children.
Yeah.
Because they were born from this marriage. So they would
Exactly.
obviously have to be placed with one or the other parent.
Yeah.
We have to talk about how they're going to be maintained. And we have to talk about the scholastic, all expenses that basically pertain to this child. So
Exactly.
this all is put on this particulars of claim. We then file it on the e-justice system, which is our court system. It's
Okay.
electronic. We file it on our e-justice system. We then issue it with a date, with a case number, and this document has to be served personally on the person that you want to get divorced. Now, why is that important? It is important because if you're going to divorce me, when we decided to get married, your status changed from single to married.
Yeah.
So when I want to divorce you, your status is going to change from divorced, from married to divorced.
Yeah.
So because it is so personal to the person, it is imperative that you serve the person personally,
Yeah.
so that that person is aware of the fact that my status is about to change again. Now, with the effect that the court will not allow you to serve that document, for example, through the deputy sheriff now, at the office of a person and give it to the receptionist and say, give it to John.
Yeah.
You want to get divorced from John. It
Understandably.
has to be served on John.
Yeah.
Now, the court obviously also makes provision for if John cannot be found, that you then ask the court for permission to serve John via the newspaper or to serve John via email. But then you have to prove that the email is the mode of communication that you've had with John for a while.
Okay.
So those are requirements. Now, once John has been served by the deputy sheriff, the deputy sheriff has to explain, obviously, the document I'm giving to John, saying that this is a document for a divorce, and you have to respond within 10 days.
Yeah.
You have 10 court days within which to respond. If you fail to respond within those court days or defend the matter,
Yeah.
then Sarah, for example, married to John, can then decide to go to court on an unopposed basis and actually divorce you without you having any say in the matter, because you've opted not to defend the matter.
Okay.
So-
Wait, Doris, before you continue, we have Matthew on the line. Pardon me. Martin, pardon me. We have Martin on the line. Good afternoon, Martin, and he's calling us from Ondangwa, I believe. Hello, Martin. Okay, we possibly lost that caller. Sorry about that, Doris. You can continue.
So once he has been served, say John has been served with the papers by Sarah,
Yeah.
John would then have the right to obtain services of a lawyer and defend the matter. And then once there's a lawyer appointed or defense noted on the e-justice system, it is immediately allocated to a judge. We in Namibia have what we call a case management system. Now, the case management system is basically where the judge plays an integral part of the process of finalizing this matter as quickly as possible. So the judge basically is in the know of how the case progresses. And this was actually brought in order to curb the time spent on cases, because in the past, it could take you up to 6 years to get
Wow,
divorced.
that's a very long time.
But now with the case management system, it's not possible to reach 6 years unless both parties are making it very difficult,
Difficult, yeah.
to get to a trial date.
Okay.
So with a judge being allocated, the judge then immediately sends out a case planning conference notice. Now, this case planning conference notice is basically where the two lawyers.
Okay, sorry, Doris. We've got Paul from Rehoboth. This is an engagement, as we said
Yeah.
earlier on. Paul from Rehoboth, good afternoon. How are you?
Double fine, how are you, man?
We are very well. What's your contribution this afternoon?
I thank for the platform. I just want to inquire regarding my youngest brother. He wants to file for divorce.
Yeah.
He consulted his lawyer because the wife don't want to do it at all.
Okay.
And once he gets hold of a lawyer, she decided that she is going to make a case of maintenance against him.
Okay.
And the magistrate court, they decided that he has to pay 2,500 per month
Okay.
without without any income or any expenditure completed on that form.
Wow.
I go back to the magistrate court and I ask them, how come do you come to a point that you say 2,500 maintenance fee she has to get hold of, whereas the income and expenditure has not been completed? And they said, no, he signed the paper, so he must pay the first payment and then he can appeal, which we did.
Okay.
He paid the first payment, and afterwards, the file disappeared from the office once we get hold of the lawyer. And he decided no, he can't afford 2,500 per month because he was bothered from his work.
Okay.
So he decided to resign from the company in order to get the lump sum.
Okay.
And it took about a year and a half in order to get off his pension. And it accumulated up to 60,000,
Okay.
which he has to pay now. Once the lawyer went to them, they said he must first pay the 60,000, and then he's prepared to go to the High Court in order to get hold of her to give him the divorce. Is that viable?
Okay, let us pose that. Thank you very much, Paul, for that contribution. We'll pose that question to our panelists. Anybody able to please assist Paul on that matter?
Okay, so what you have to understand, Paul, is the fact that when the maintenance court makes an order, it is an enforceable order. So once the order was made in respect of the $2,500, it was an order that unless you appeal against it, it stands unless appealed. So the unfortunate part is that if you did not appeal, that amount was payable.
Okay.
And with the divorce, what transpires is that when we, for example, when the divorce process is ongoing and a person has a maintenance order, that maintenance order remains in force until the High Court makes an alternative order in the divorce. So if we, for example, in the settlement agreement says that the order from the maintenance court will remain, then that is what's going to remain. And if it is changed at the High Court, then that order would then substitute the other order. Otherwise, that order stays, and that is why that amount is payable.
So the fact that Paul's brother most likely didn't appeal at the maintenance stage is what created the problem, and unfortunately now he will
Because
have to pay.
the amount just
Yes.
accumulates.
Yes.
So now he
Until
will
the-
have to pay
Yes. He
in
has
order
to.
for him to continue with the divorce process.
Because that amount is in arrears.
Yeah.
Yes.
Oh, shame.
But I wanted to add that when it comes to the divorce, he himself can also institute divorce proceedings, because the fact that there's a maintenance order against him
Yeah,
does
doesn't
not
stop
bar him
Oh,
from
okay.
continuing. Because sometimes what parties do is that when one party institutes divorce, it becomes like a game of
Yes,
chess.
yes.
You make this move, I make this move.
Okay.
But there's nothing that stops him from even instituting divorce proceedings.
Okay.
And that nothing that stops him from going back to the maintenance office and say, okay, so you're saying I must pay 50,000.
Yeah.
Can I pay it off in this installment? I don't think the court will be so unreasonable and say, pay the 50,000 or nothing.
Okay.
Yes.
Okay. So there are still options, Paul, for your brother that he can take. Firstly, Ms. Felicity has indicated that he himself can actually approach to institute a divorce from his side. And secondly, you can create a payment option with the court to try and assist you to alleviate the pressures of having to pay a lump sum of the $50,000.
But you must understand it has to be with permission of
Yes.
the complainant.
Okay.
Because if the complainant
okay.
doesn't agree,
Yeah.
your asset can actually be sold. I can
Wow.
sell your house for maintenance.
Wow.
I can sell your car for
Yeah.
maintenance. Because
Okay.
you must understand that the court, when it comes to maintenance matters, are taking a very hard approach nowadays. Because
yeah.
remember, kids have to eat.
Yeah, exactly, exactly. So I think the best thing is, for people to try and communicate, so as to try and avoid some of these
True.
gruntling,
Yes.
things that come up. So, we've got another caller on the line. We've got Joseph from Walfish Bay. Good afternoon, Joseph. How are you this afternoon? Good.
Blessed. How are you, man?
We are also blessed. Please do make your contributions, but make them as short as possible, please.
Yes, no, I just quickly have a question to ask. I've been married now for a very long time, but I'm not with my wife for 5 years right now.
Okay.
Yes, and then she's now living in Windhoek. I'm living in Walvis, but we are no more for 5 years. We're no more together.
Uh-huh.
and then I have already made my applications for divorce, but I'm still waiting. Nothing has been yet done. When I'm going to the offices, they are telling me to call where, and to call where.
Okay.
Yes, and both me and my wife, we all both moved on because she's even living with her house, with a boyfriend in Windu.
Okay.
Please ask
Yeah.
him
So
what
I need help
application you
now
made.
because I've been in offices, but nothing has been yet done.
Okay.
Joseph, may I ask with which office you brought where
Yes.
did you bring the application? Where did you make the application for a divorce?
Yes.
I went to get the labor office.
At the labor office.
The legal office.
Legal aid.
Legal aid.
You must understand, Joseph, when you bring an application for legal aid, it's when you cannot pay for a divorce because the legal aid lawyer is supposed to then assist you.
Yes.
But you have to follow up with that office. So it means that if you are not getting any joy from calling or emailing them, then you would have to come to the office in Windhoek to follow up on your application. Because normally what they would do is they would send you a letter. Once they've received your application, they send you a letter acknowledging
Yes.
that they've received your application.
Did
And
you receive
once-
that letter?
Sorry?
Did you receive a letter saying that they received your application?
No, I did not yet receive the letter.
Then you must follow up because it might be that your application got lost. Because they would,
So I need to go again.
you'd probably have to do that, and you have to make sure that they receive it because they would normally write the letter saying we received your application. That's what they do. Yes.
And Joseph, if I want to add, in your legal aid is there's a means test that is applied. So you need to have a salary of $3,500. You must be below that. Yes. And
$500.
yes, in order to qualify. Of course, sometimes they look at cases also in merits, and the director of legal aid has a discretion to grant legal aid. But in case your application is lost, I would suggest that you apply again, because sometimes people give the postal box of maybe a neighbor or someone else. And so, but after a week or two, you follow up with legal aid.
Okay.
Yes.
All right, thank you.
Okay, thank you very much, Joseph, and I trust you have been assisted.
Okay, thank you, ma'am.
Okay, thank you much for that contribution. We would like to get back to some of the questions that we had here. And Ms. Felicity, maybe you can help us to understand that there is a proposed reform with regards to the divorce law. What are the proposed reforms that are in place right now, that are being proposed, and how do they compare to the current laws that are in place?
Okay. Yes. So under the proposed law, we actually want to remove the element of fault. Currently, you have to state one of the four grounds. So under the new law, all you need to say is the marriage has irretrievably broken down. You don't need to state the facts and the dates. That's the only statement that you can make in order to get the divorce. The other element is two parties can jointly approach the court for a divorce and say, the two of us agree that we don't want to get married, we want a divorce, and the court can grant an application based on the joint application. The other aspect is the access to courts. Currently, only the High Court of Namibia, the main division, and the Oshakati division can grant a divorce. Now, in terms of the new law, there is a proposal that the regional magistrates will be given jurisdiction to hear and determine issues relating to divorce and to make orders regarding divorce. And that's basically to lessen the burden that's currently on the High Court in dealing with divorces, and also to assist those in the regions and the remote areas to obtain divorce orders. So that's on access. And then the other aspect is currently, like I said, there's a restitution of conjugal rights order which the court is obliged to make. Now, under the new law, a party can ask that the court grants a final order immediately. But if it is an opposed application and the court sees that there are prospects of reconciliation, the court can postpone the divorce for a month or more or lesser period in order to allow for that to take place. Okay. So, and the other aspect is the aspect of mediation. Currently, there is mandatory mediation, especially, and Doris has to correct me here, when divorce application is opposed. And the parties are required to go through mediation. But mediation sometimes doesn't work because it also becomes a game of chess. If you do this, I do this, and this prolongs the process. So the current, the new reforms will also cater for that in which instances. Because the court can give you a court-connected mediator, or you can approach your own mediator. So this is also to help parties to come up with settlement agreements when it comes to divorces. And the other aspect is the aspect of fees that can be charged. The fact that the proposal is to remove the conditional order, the restitution of conjugal rights, that will hopefully reduce the amounts the parties have to pay in order to obtain the divorce. And let me say this. Do-it-yourself divorces are allowed, right? But like Dora said, you need to get proper legal advice before you do that because it's a change of status. If there are children and property involved, and there has been a mistake, who are you going to blame? So it might be to your disadvantage, but do-it-yourself divorces are allowed. The other aspect is, just allow me to quickly scroll through my notes.
Sorry, Ms. Felicity, we've got a caller here on the line.
Yes.
Just before you continue. Good afternoon, caller. Welcome to the show.
Good afternoon.
Yes.
This is Paul again.
Okay, yes, Paul.
We just called in about my brother. So I'm hearing about the game of chess. I think the wife is playing the game of chess.
Okay.
But when you're giving the answer, after we paid the first premium of 2,500 without the income and expenditure not being completed, we appealed. And that file got lost somehow within the magistrate. And he resigned. It took about a year and 6 months in order for him to get his pension, so the arrears went up to 60,000. Whereby his salary was frozen, his pension money that he received was frozen, and they took the other amount and paid to the wife, and he still had arrears of 23,000 that he had to pay. But my mere question is, without that form of income expenditure being completed, how come did it come to 2,500 to be paid? That's why he appealed in the first place, and then the file got missing. Once we get hold of a lawyer, but we still need to pay that amount. Well, he appealed. That's my question that I'm having.
Pardon me, will he appeal?
He appealed.
No, the question that you're posing, Paul, right now is?
It's about the income and expenditure not being completed on the form, and they come up with an amount of 2,500 to be paid.
Okay.
Fine. Anyway, I went back to the magistrate, whereby they make the settlement. I told them the income expenditure part is not completed. How come did you come to a point that you say you must pay 2,500? They said, hey, you signed the paper because it was under stress. He just decided, let me just sign and get it over with.
Okay.
And they told us, first pay the 2,500 for this month. Afterwards, you can appeal.
Okay.
And we appealed. And then he resigned immediately from the company because he can't afford 2,500. And that file was in the magistrate court, got lost when we get that lawyer.
Okay.
After the arrears are going on, which is up to 60,000, because what the lawyer is currently doing is trying to avoid that maintenance part so that they can just get divorced. But how come the income expenditure wasn't completed? We appealed. Apparently, the file got missing within the offices. But
Okay.
now, the arrears went up to that because it was waiting for
Okay.
6 months for his pension.
Okay. Thank you very much, Paul, for that call. We'll pose it to the panelists and see how best they can respond to that.
Thank you very much, ma'am.
Okay.
Personally, I would like to advise Paul to go and see a lawyer because
Okay.
he clearly needs legal advice. And it's also very difficult to give advice on a platform such as this.
Yeah.
Because the facts keep on changing. Because if you don't have all the facts, we can't advise you properly.
Yeah.
So it's imperative that you go and seek legal advice. If your brother cannot afford legal advice, you can apply for legal aid so that you are properly advised on this matter.
Okay.
And if I may, I
Yeah.
would just like to proceed, before she proceeds with the proposed amendments,
Yeah.
and it's in particular to the process of a divorce.
Yeah.
Because if you look at, once a judge has been allocated and there's a case plan reached, because remember the case plan's purpose is basically to set out how you're going to deal with the
Yeah.
divorce. You would have to ask for mediation. And as Felicity just stated, mediation is mandatory
Yeah.
at this stage. Now, mediation is the process where the parties actually have an opportunity to speak to each other.
Okay.
You must understand that when people get divorced, the first thing that normally goes is communication.
Yeah.
So what the court has implemented is that there's a process before people start throwing their dirty laundry at each other. You get a process which is closed off. It's
Okay.
not public.
Yeah.
It's you, me, our two lawyers, and the mediator. The five of us sit in a room, and we can actually discuss our marital problems in a closed session.
Okay.
And then we can amicably resolve our issues.
Yeah, yeah.
So that process is very important. And if properly used, it can actually cut the divorce costs with more than 50%. So that is why mediation is so important. But only if mediation fails, then you go further and people start filing court papers where you then say why you don't agree with my reasons for divorce.
Okay.
And then if a trial date is set, you then have to wash your dirty laundry in front of the public.
Yeah.
And that is why we basically want to encourage people to make use of mediation as to fast track the process
Okay.
and make sure that you settle at that stage, because
Yeah.
then you can actually get divorced within 3 months, 4 months.
Okay.
Yes.
Okay. It's very good information, and I hope somebody has been educated and been given some form of hope to try and know what to do and also how to do it. Unfortunately, time has caught up with us, but we just quickly as possible, we would like to speak to the public engagement that needs to be done with regards to this reform. How, where, just quickly, why,
Okay.
and also in your conclusions, just where can people get more information with regards to these?
Okay. Thank you. Okay, so currently we have stated that the comments must be made by 4 April. But I've consulted the minister, and we've agreed that you can give comments until the 8th of April. Currently, the bill as well as the policies on the Ministry of Justice website, www.moj.gov.na. But the bill can also be obtained from the public relations officer of the Ministry of Justice, as well as a legal officer that is stated. I can actually forward the document to you. So yes. So but and also the comments can be delivered personally to the minister's office on the 3rd floor at the room 303.
Okay.
So that's where public can submit their comments.
Okay, okay. Thank you very much.
Maybe just in conclusion, I would like to add the following, that the reforms are there to make the process easier, but what we need to understand is that it's not only about making the process easier, we should also consider the societal fabric. You don't want people to get married for all the wrong reasons and get out of it as quickly as possible.
Yeah.
What I always say is that the restoration period that was put in was in order to give parties time to reconcile.
Yeah.
I have done a number of divorces where people actually during that restoration period reconciled.
Okay.
And I also have where people at mediation reconciled.
Okay.
So it is imperative that when we look at the proposed new law, we need to take into consideration the fact that you don't want to degrade the societal fabric by making it so easy for people to get divorced.
Okay. Okay. Thank you very much for joining us. I do hope that you have learned something. As we said, please do go to the different various legal platforms, especially that of the Ministry of Justice, for more information, and do partake in the comments that are required from the ministry, if you have any, on the proposed reforms. With that said, from myself, Shianwa Desire Kahiha, and my panelists on stage, and my production crew, bye-bye.
Bye.